Can you settle your medical malpractice case without ever going to trial? Would you like to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, yes, you could. And you might be asking, okay, when? When along the course of your entire litigation is it possible for you to actually settle your case? I'll tell you when. You can settle your case immediately after you actually start your case. When the defense turns around and says, you know what? Before we serve an answer to your case, we want to go ahead and try and settle. So that's a possibility. After we let the court know that all the attorneys involved in this case are now present and now we want to go through discovery, guess what? The defense could try and settle this case at that time before you even start discovery. How about during the course of discovery? The answer is yes, they could. And now, the point is the defense can make an offer at any time during the course of your litigation. Okay? There's no set definable time there's no set definable time when an offer can be made. Did you know that a settlement offer can actually come before you give your pretrial testimony known as deposition? That's true. It could also happen immediately after. It's not likely to because the defense is still learning about your particular case. They're learning about your injuries. They're learning about your disabilities. And for them to try and make an offer at this early stage is highly unlikely. All right, so now what happens when we notify the court that your case is actually ready for trial, that all the discovery is finished? Could it happen then? The answer is yes, it could. Okay. Is it going to happen then? Again, it's unlikely because at that point, once we notify the court that your case is ready for trial, now in all likelihood the defense is going to try and get your case dismissed without the need of ever having to go to trial. They're going to ask the judge on papers to throw your case out. It's called making a motion for summary judgment. And that's nothing more than asking the court to take action, formal action, on your particular case. And that's a topic for a different video. All right, but let's get back to this topic. Can they settle a case at any time during the litigation? Yes, they can. Now, as we move on and get closer to trial, guess what? Can the defense try and offer and can you try and settle your case before you ever reach trial? The answer is yes, you can. You can try and do that. You might be able to try and do that through mediation. You might be able to try and do that privately where the attorneys get together on the phone, say, listen, here's what we're offering, here's what we'd like. And now you try and negotiate that way. Is there the possibility that the defense could try and settle your case when your case comes up for trial and now you're in the middle of jury selection? The answer is yes, you can. What about after you've started your trial? Is it possible to try and settle your case during the course of trial? The answer again is yes, you can. What happens if the jury actually reaches a verdict and now the defense appeals it, claiming that the verdict is too high or inappropriate? Can you settle your case after the verdict has been reached and the jury has spoken? The answer is yes, you can. So literally, your case could be settled at any point in the litigation process, from the time you start your case all the way through a verdict and actually through the course of an appeal. So why do I share this great information with you? I share it with you because I have a few moments to share this terrific information and I wanted to help you understand how these types of cases work. You know, I do recognize you're watching this video because you likely have questions and you're not watching it just for the scenery, and that you have questions about your matter that happened in New York. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.